Stuart-Smith, before the break, said the following. He suggested that if there is no unsatisfied demand for tax, then SCAT, the proposition was, cannot be seeking to enforce a claim for tax. So in other words, as I understand the point, that even if, as I was arguing on the context of Williams and Humbert, that is not a statute, it is still an important guide, potentially, to the question of whether there is a claim to enforce a claim for tax. Now, briefly to round this point off before I move on, the court has my submission that Williams and Humbert shouldn't be treated rigidly, and that in that particular case, the importance and the significance was that it wasn't being brought by a state, it was being brought by private individuals, and it was that much more difficult to untangle what, if any, sovereign interests were in play. And in that case, on the facts, clearly, absolutely not, given that the state involvement was tenuous, to say the least. Secondly, the court has the point, which will be an important part of Mr. Beale's submissions, that in fact, claiming back a tax refund in this case is a claim for tax, and that's something which he will develop in due course. But thirdly, and picking up on the submission I started with this morning, which was that the tax principles, the tax cases, have to be situated very firmly within the overall framework of what is a sovereign claim. In other words, they are not in their own watertight little box with exclusive rules of their own. That takes me on to my next point, which is that the touchstone in this case and all Rule 3 cases, as the judge rightly found, is to pay close attention to exactly how the loss was sustained. So developing that, the court has my submission from this morning that the analysis of this court in Masogo, simply reviewing and synthesizing centuries of case law which came before that, is of general application, it's of general assistance, regardless of whether the appellant describes the case as having a tax background or context. And what I'm going to focus on here is a factor which was central to the learned judge's decision on where to draw the line, and yet about which the appellant has very little to say. Indeed, my friend for the appellant did not discuss it yesterday at all. And this is the question of how the loss which SCAT alleges was suffered. So to introduce this issue, may I ask the court to turn to the judgment and to go to paragraph 66, which is on the electronic version, CB1, tab 3, page 20. And my lords, may I ask whether it looks as though the court is working from paper copies of the judgment, and therefore it would save me a little bit of time if I don't bring passages from the judgment specifically, although I will for all the other cases are up on the screen, but would it assist if I continued to make sure that the passages from the judgment are also displayed on the screen? Because we can certainly
I'm working electronically, but I'm not on the presenter screen.
Yes. Well, my lord, in that case, I will continue to give the electronic references, and let's just have them up on the screen as well for these. Paragraph 66. The judge says, it's inherent in the Court of Appeal's decision in Masogo, paragraph 62 above, that in the context of Dicey Rule 3, how loss was suffered is an aspect of identifying the substance of the claim in order to determine whether it is sovereign in character. And to ground that proposition, the judge then cites paragraphs 58 and 59 of Masogo, and this is an aspect of the case that wasn't examined yesterday. So if I may, I will take a minute or two to look at this. The decision in Masogo can be found at Principal Authorities 3, tab 22. I would pick it up at page 28 of the electronic version. And I'd invite your court's attention to the heading one sees just at letter D, conclusions of principle. And we see paragraph 50, what I would submit is an extremely important part of the analysis. Picking it up 3 lines down, the critical question is whether in bringing a claimant is doing an act which is of a sovereign character or which is done by virtue of sovereign authority, and whether the claim involves the exercise or assertion of a sovereign right. If so, then the court will not determine or enforce the claim. On the other hand, and I pause here, and note the court goes on to identify 3 features which a case must not have in order to escape the application of the rule. So they say, on the other hand, if in bringing the claimant is not doing an act which is of a sovereign character, or by virtue of sovereign authority, and the claim does not involve the exercise or assertion of a sovereign right, and the claim does not seek to vindicate a sovereign act or acts, then the court will both determine and enforce it. It's framed in the negative there, but one sees the breadth of the description. And when we move on to the next page, because it's instructive from my submission to see how that abstract statement of principle of the sort with which the case law in this area is replete, obviously the devil is in the details, and it's my submission instructive to see how that was actually applied to the facts. So we have across the page at 29, starting at B, there's a section application of the principle to the facts. And jumping down to 55, we see the court making clear that there would have been some claims that would have been available to Equatorial Guinea following the coup. And I pick this up 3 lines down. If the alleged coup had been successful and damage had been caused to buildings or other property owned by the claimants, a claim in tort to recover damages would have been justiciable in the courts of this country. In bringing such a claim, the claimants would not have been exercising or asserting sovereign authority or seeking relief to vindicate an act which may only be done by a sovereign in the capacity of sovereign. Picking it up again a couple of lines further down, such a claim would have arisen solely from the fact that the claimants were owners of property that had been damaged by torts committed by the defendants. The claim would be a patrimonial claim, to use the language of Lord Keith in Government.
Could I ask you, or someone else, if there's anyone else as well qualified as you, to tell me what exactly is and is not included in the phrase patrimonial claim? Because in the very helpfully you took us to the passage just back where the court says if it's this it is, and if it isn't this it isn't. I'm not at all sure that either as a term of art or as being used in these cases, patrimonial has a clearly defined meaning.
I would agree with your lordship.
Is it a Scottish legal term? Because it's used by Lord Keith of Avonham in Government of India and Taylor.
Despite my accent, my knowledge of Scottish law is almost
That wasn't actually directly
zero.
personal. It just seemed to me it might very well be.
I believe that it is used I have seen it used in Scottish case law. But in answer to my lord's question, that is quite correct. It is a slippery term, and it's sometimes used. We see it used in different ways in the case law. Sometimes it's used in a purely sort of mopping up sense to mean cases which aren't sovereign, but that are brought by a sovereign. Sometimes it's used in the sense of, and I think the Court of Appeal may be using it in a sense that might, in this passage, do more justice to the word patrimonial, because the court here is saying very specifically, and I'll pick up the property example in a moment, but the court here is saying, with particular reference to damage to property owned by the government of Equatorial Guinea. If someone had smashed their window, they would be a property owner asserting a patrimonial claim. Sometimes it's used in a sort of mopping up sense, frequently, to mean purely claims which aren't sovereign, which just begs the question. However, one also sees possibly the most detailed analysis is that of Lord Denning in Ortiz, in the passage which I took you to this morning, where he doesn't just use patrimonial as the flip side of sovereign, a sort of bucket that catches everything that isn't a sovereign claim, but that is brought by a sovereign. He uses it, he ties sovereign to the concept of iure imperii, and he ties patrimonial to this concept of iure gestionis, and in my submission that's the most helpful way of looking at it. In other words, sovereign claims are those which involve in some way, I'm going to come along in a moment to look at the specific Mbasogo and trial judge twist on this, which we say was right, involve in some way sovereignty, and we just saw the 3 flavours of sovereignty that must not be involved in the claim, in this court's view, in paragraph 50, to make it not sovereign. And Lord Denning, of course, tied it to the concept of, tied patrimonial to the flip side of iure gestionis, or matters which states do as part of their general commercial life, or the life which they happen to have, but which private individuals may have as well. I know that's not a crisp answer to the question, but the answer is that the case law isn't crisp on this, but in my submission, Lord Denning is probably, and the 2 articles which the court has by Dr. Mann in the bundles as well, is the places where this is paid most close attention to.
Thank you.
And so when we think about this paragraph 55 and the idea of damaging the building, this is, and I hope the court can see with relief that this is me taking some steps towards looking at the concrete examples that the court has posed. Why would it, we ask ourselves, have been permissible for Equatorial Guinea to sue in England for damages to its buildings, if its buildings have been damaged during the coup? We have some of the answer, as we've just seen at the end of 55. Such a claim would have arisen solely from the fact that the claimants were owners of property that had been damaged by torts committed by the defendants. But then at 56, the court goes on to make even clearer why that would be. And the court says it is necessary to look at all the circumstances to see whether, in substance, the losses which are the subject of the claim have been suffered by virtue of an exercise of sovereign authority.
55, it seems to be important there that that the claimants had ceased to be sovereign.
In the sense that
The coup had been successful.
I had not myself, my lord, read 55 as in any way turning on the proposition that there had been the coup failed ultimately. I hadn't read anything in Mbasogo as turning on the proposition that the any particular individual had been deposed.
That's what it said. If the alleged coup had been successful.
I apologise. If I'd understood your logic to be saying that the alleged coup had on the facts been successful, yes, precisely. I think the confusion may arise, my lord, because as one sees from the rest of the judgment, the claim was in fact in conspiracy, so there wasn't in fact much physically that had been done. So I think the court is suggesting that if the coup had been successful in the sense that the mercenaries, so we see that it was primarily in conspiracy, and what was said to have been done was plans had been laid, and we see this at, I think, paragraphs 4, 5 and 18 of the judgment. Plans had been laid, weapons had been procured, but in fact, very little by way of actual physical implementation of the plan. So I think, in my reading, this court is saying if the alleged coup had been successful in the sense, not in the sense that there was a change of sovereignty in Equatorial Guinea, but in the sense that the mercenaries ended up, the armed mercenaries, had got to the point where they were on the streets doing things, and in the course of that had damaged the buildings, then the rest of the analysis from that paragraph flows.
I'm not sure about that.
No.
Well, in my submission, it wouldn't follow. We do see from the facts that the coup had not been successful in the sense even that the mercenaries hadn't taken to the streets. And in my submission, there wouldn't be
what does it mean for a coup to be successful?
Well, I think we have to.
Another government takes over. But the last three sentences of 55 are in very general terms, aren't they? Where they say they, that is the claimants, would have been exercising the right of any person to bring private proceedings to recover damages for loss suffered as a result of a civil wrong. So that's suggesting that if that is the correct characterisation of a claim, the fact that the claimant is a sovereign government is neither here nor there. And then the next sentence seems to be referring back to damage to buildings because it says they would have arisen because they've been the owners of the property. So I think the patrimonial claim seems to be effectively a proprietary claim of one kind or another.
My lord, yes, certainly my reading, and we can only, of course, seek to understand what was written there by the court. But in my reading, certainly that the sentence, if the alleged coup had been successful, when tied to the fact that the court is going on to discuss what it considers would have been the availability of property claims for damaged buildings, does not depend, the logic there doesn't depend on, well, the court isn't saying those claims would have been available because the previous government would have been deposed. They're saying, we're just positing a factual scenario in which physical damage had been done to buildings, which it wasn't in fact in this case because the conspirators didn't get any further with their activities, if that makes sense. So the court then says, we've just seen at 56, it's necessary to look at all the circumstances to see whether in substance the losses which are subject to the claim have been suffered by virtue of an exercise of sovereign authority. And it's interesting and important in my submission if we turn the page again to page 30. I apologise for taking this in some detail, but it is, the gritty detail here is helpful, I would suggest. If we look at paragraph 58, we can see the court's summary. They summarise the pleadings in greater detail at the beginning of the judgment. We see the court's summary of what exactly Equatorial Guinea was claiming for. And one sees that most of the headings of claim start with the word costs. In other words, they paid money out for a variety of things as a consequence, they alleged, of the conspiracy, the wrongful conspiracy that they pleaded. And the court, and so of course it would have been possible, and I'm going to go on in a moment to how the judge looked at SCAT's characterisations of its claims in this case, but it would have been possible for Equatorial Guinea to say, well look, we paid money, everybody, private individuals can pay money, private individuals can pay money for security if they feel that they need to, or they're under threat. So there's nothing sovereign about this. But picking it up 5 lines from the bottom of paragraph 58, we see the court saying, having set the losses out, with one possible exception, they are losses which could only be suffered by the governing body of the state. They arose as a direct result, and these are words on which I do place some emphasis, of the government's decisions as to how to respond to the conspiracy, and subject to the possible exception of a kind that could not be suffered by anyone else. And just to round this point off, for the possible exception, we can see this in the next paragraph, where we see that one of Equatorial Guinea's claims was for losses suffered as a result of delay to infrastructure projects that it had planned. And the court sets those out, but then it says it's artificial to describe these losses as property losses caused by the defendant's actions and treat them as if they were similar in kind to, for example, the cost of repairing a government building damaged in the course of a coup. It's clear from paragraph 44A and B of the pleading that it was not the defendant's action alone which caused the foreign nationals to leave. And the court will see that the foreign national contractors leaving Equatorial Guinea was the factor, because presumably they found it an unstable environment, was the factor that then led to the delay to the infrastructure projects and thus to the profits which Equatorial Guinea had hoped to realise from those projects. So just a very small point on that. When we see the sentence, it was not the defendant's action alone which caused the foreign nationals to leave. In other words, causation here was mixed. And if there were any sovereign aspect between A, the wrongful conduct, and B, the loss, then it appears that the court was saying that the claim is properly characterised as a sovereign one. And perhaps we can leave this page on the screen. I'm going to come back briefly to it shortly. Now, the court raised a number of concrete examples in discussion with counsel both yesterday and today. And without neglecting those specific examples, which I'll come back to in due course, taking step by step from this analysis in Mbusogo, I would pose the example of an English resident who goes to Copenhagen and puts a brick through the window of Skat's offices. Now, clearly, we can see at a glance that there's no Rule 3 problem. Skat sues her in England for the damage to the window. But I'm trying to articulate why that's the case. We have the answer, I would submit, in paragraph 56 of Mbusogo. The loss, in that case, was not suffered by virtue of any exercise of sovereign authority. So whether one looks at the mercenary in Equatorial Guinea damaging a government building if the coup had got off the ground, or the person smashing Skat's window, one has A, the wrongful conduct, throwing the brick, and one has B, the loss, broken window, and there is nothing sovereign, there are no sovereign choices, such as Equatorial Guinea took in responding to the claim, between A and B. So in other words, the loss, the court is saying here, not considering the broken window in Copenhagen, but considering the hypothetical damaged building in Equatorial Guinea, the loss crystallises directly by virtue of the tortious acts. Throw the brick, the window is smashed. And with that concrete example in mind, we can now turn back to the judgment briefly, which I'm taking in a little detail because this is a critical aspect to my submission of the judge's
Are you using
reasoning.
directly in any technical sense there? You say the loss is directly caused by the brick. There's obviously a clear causal connection between the throwing of the brick, the flight of the brick, the impact of the brick. Are you saying anything more technical than that?
No, my lord.
Does it
Simply
matter?
on a very-
Does it matter that it's direct?
It matters in my submission that the loss. So if one says one has the wrongful act, in this case the throwing of the brick, one has the loss, in this case the damage to the window, it matters in my submission whether one uses the word direct or indirect, and of course causation is always an evaluative exercise rather than a description. But it matters on the analysis of this court, paragraph 56, that the loss was not suffered by virtue of any exercise of sovereign authority. So the point is, between the throw and the smash, there's no exercise of sovereign authority.
Right. So if two people had gone to Copenhagen conspiring to put a brick through the window, but only one of them did, it wouldn't make any difference, the fact that the other person was merely a conspirator to procure a result.
My lord, yes, because still between the wrong and the harm, there would be no exercise of sovereign authority. There would be two conspirators. Obviously, questions of loss and causation when there's a mere conspiracy that's never been actioned then rear their heads. But one person then throws the brick, so there's the fact that there were two conspirators and one throwing the brick would not inject the necessary elements of sovereign authority between the throw and the smash of the window.
What this means is that you're focusing incredibly narrowly upon the payment out of money. Because it must be what you're saying is that the payment out of the money is an act of sovereign authority.
My lord, there are
You're about to make that submission.
The court can see yes is the answer, and I'll answer it in greater detail in one moment if I can then
That's
give
the only point, that's the only thing here that distinguishes this from the broken window, isn't it? Is that the state is engaged, the only thing they do is pay out the money,
Decide to pay out something.
decide to pay it out and pay it out.
My lord, it would not be our submission that that is the only thing that they do.
So having been induced to do so by the fraud on this hypothesis. So that's the exercise of sovereign authority, is it? Precluding a claim
Yes.
under the revenue rule against the fraudster.
In my submission, yes. The payment of the money is somewhere in the middle of a range of acts of sovereign authority which stand between, in this case, what Scat says is the wrong. So the equivalent to the throwing of the brick is the
You said it's the
making out of
loss.
the-
How was the loss caused? The loss was caused by the paying out of money, which was induced by fraud.
My lords, yes, the payment of money was the final stage in a series, the respondents would say, of sovereign acts, starting with the receipt and the assessment as being due, and the decision to grant the refund applications.
So you accept that all of that process is written water, isn't it? Because it's all by virtue of a fraudulent application on the hypothesis we're working on.
Oh, no, that's the appellant's case, yes, and that's the case which I'm seeking to break down and show why that's very much not the respondent's case, and the respondents make the submission that that's wrong.
Let's imagine that X is due a tax refund because they're the shareholder. They received a payment of, they received a dividend, and they are justly entitled to a refund. But Y comes along and impersonates X and puts in an application for that tax refund, and Scat pays it. So the money is paid to completely the wrong person on a completely wrong basis. On your analysis, that must also be an exercise of sovereign authority.
Can I clarify? So the source of the misrepresentation is as to the identity of the person who is.
Well, there may be any number of, but that is basically it's identity. Basically, somebody's come along and says, "Give me the money. It's due to me."
It's the same point as we debated yesterday, the mistaken identity induced by fraud, and whether there's some difference in principle between that and this case, which is on the factual hypothesis we're asked to proceed, is a case where the fraudster doesn't seek to impersonate somebody else, but puts forward a fraudulent assertion that he is a shareholder and that he has paid.
The reason I ask it is because the judge seemed to think this might not be a dicey Rule 3 situation, and yet on your analysis, it's got to be an exercise of sovereign authority.
Yes, and the judge's conclusions on this point stemmed. So I was the person who addressed this sort of area at trial, and his conclusions on that point stemmed from a number of hypotheticals that we naturally explored at trial, because this case cries out for concrete examples to test the parties' various propositions. And I can helpfully employ one of the hypotheticals here to show the distinction. So, with the caveat, I think that we need not answer in this appeal every possible permutation of fact that there could be in relation to a sovereign revenue. But that said, the example that we explored with the judge at trial was a situation of identity theft once the refund had been held to be due. So imagine that person A submits a perfectly legitimate claim for a refund and is assessed as being due. That, in our submission, is the act of sovereign authority. Scat takes the refund, it runs the tax system, no private person runs a tax system, it assesses it, decides person A is completely legitimate, and it's right to decide that. If person B, in some way, gets her hands on the money that's been assessed as due to person A, whether by identity theft, whether I think we posited a situation at trial that if it was Scat driving around with a van full of money and it was handing it out to the right people and robbed the van, by whatever way person B intercepts the money that Scat has decided is rightfully due to person A, that does not necessarily engage the revenue rule in our submission because the sovereign aspects of it have all been done.
What about payment? The payment is the sovereign act.
Well, my lord, if it's a pure payment of money that's been assessed as being due to person A, then one would have to focus very closely on the precise circumstances of the interception, and the border would lie somewhere around there.
But that's the problem with analogies. I can see the force of your example, but as you say, the fraud in that case cuts in after the sovereign act. So on your analysis, you've got a sovereign act, and then it is subverted later. I can see that, but what we're concerned with is something which in normal circumstances you would characterise as a sovereign act, namely a decision to pay, but that decision itself has been subverted, if I can use that term, because it is the product of a fraud which is designed to ensure that the sovereign act is subverted in that way. Now, I'm not sure that there's any, apart from bricks and things like that, I'm not sure that analogies really help, because we're right at the nub of the problem, as it seems to me, on ground one, which is what is the effect, allowing for the sake of argument, that this can be a normal refund decision can be treated as a sovereign act. What is the impact if that's otherwise sovereign act, not being tendentious, but otherwise sovereign act, is procured by fraud?
This
And
is
that
exactly the point that the American authorities addressed, that Lord Panic referred to yesterday, and which the judge actually refers to expressly when he's in paragraph 68 of his judgment, where he refers to the passage from Dr. Mann's 1987 article, as opposed to his 1954 article, where he cites the land Lord Rhine-Westphalian case and the conclusion of the New York court that well, let's call it the revenue rule. It's not the revenue rule, but the rule would not apply because what was entailed was not vindication of public justice, reparation for fraud. Now, on that analysis, this claim would not be precluded by the rule, because, as my lord says, it's effectively, even if it was a sovereign act, it's been induced by fraud. They wouldn't otherwise have done it. That's the point.
But in your very careful analysis, I followed your submission that the rule isn't only related to revenue; it goes to a wider category. And at the moment, I'm happy to operate on that basis, making no promises. But it doesn't seem to me that that part of your analysis actually addresses the problem we've got at all, which is what's the effect where the system is subverted by fraud. That's the way I put it.
There are, just going back to the couple of points that have been raised there. Firstly, my Lord Justice Stuart-Smith, and I was respectfully agree, suggested that analogies are limited here. I was concerned to build a framework to address the analogies which were raised by the court yesterday in testing those propositions, but I'm very happy to leave those aside because, as one says, we are in a tax situation. We haven't got bricks and windows, although those cruder analogies help one when one's just getting to grips with what the court was saying in Solo. The point that the tax refund system ceases to be a sovereign mechanism if it has been subverted by fraud goes really to the heart of Scott's criticism of the judge's reasoning, and where I would propose that we pick that up in order to answer that question, because my answer is the judge was quite correct to say that however you characterise the wrongdoing, so in other words, on my attempt, I hope helpfully, to break down in Basogo into distinguishing between the wrongful behaviour and the mechanism of harm, the wrongful behaviour in Sunico being the conspiracy to commit the coup, the procuring of weapons, etc., and the harm being the losses which we've seen pleaded there, the costs, the various increased costs to the state, and between those two things lying, as the Court of Appeal said, the sovereign decisions as to how to respond to that wrongful conduct. We can look at the judgment and show the passages where the judge, in my submission quite correctly, showed that two things. Firstly, that he fully appreciated, and one would expect that as the judge who had case managed these vast claims for some over a year at the point of this judgment. He fully appreciated, and he very carefully records, and I'll show the court in a moment, all the different permutations of the wrongful conduct which is alleged, up to and absolutely including the hardest edged version of the fraud case. So he completely understood what was being put, but he, in my submission, correctly said, well, one can build up the wrongdoing with reference to various states of mind. So it could be, there were misrepresentations, Scat said. Were they negligent? Were they fraudulent? One can change the state of mind on that side of the equation, but it does not. And this is the critical point of the judge's reasoning and how he got to the conclusion that this was, in effect, a sovereignty claim. One can make the wrongdoing sound as bad as one wants for the sake of argument, but that is separate conceptually, just as it wouldn't have mattered how bad the conduct of the conspirators was in planning the coup, or how destructive the coup was planned to be. That didn't answer the question that the mechanism by which the harm was caused to Equatorial Guinea was the choices made by that state as to how to respond to that situation. Now, that was a situation which, on Equatorial Guinea's case, was wholly wrongful, unconstitutional. It shouldn't have been put in, worse than fraud. And if I have time at the end, looking at separately at the public policy exception, I will take the court to the judgment of the Judicial Committee of the Privy Council in Sunico, where they emphasised and showed that they were well aware of the public policy concerns in the suppression of terrorism, but nevertheless held the claim to be inadmissible. But if the nub of the issue is the fact that on the wrongful acts side of the spectrum, there were misrepresentations which are said to be, does it make all the difference that they were dishonest misrepresentations rather than, say, negligent ones, then in my submission, no, it does not. The administration of the tax system does not cease to be sovereign. In other words, it doesn't, and to pick up the exchange with my Lord Justice Stuart-Smith earlier on, just after lunch, where my Lord asked in what sense the word patrimonial is used in this context, and there are really two sides of the coin. The tax system doesn't cease to be sovereign. In other words, to flip the coin around, it doesn't cease to be something that a private individual can do by reason of the fact that on the appellant's claim, the refunds were not in fact due.
Forgive me, I think, if you don't mind me saying respect, I think this is all missing the point. Because, of course, one could look at what the wrongful acts are, and you say they can be more or less serious. I understand that. And you can understand about the mechanism of harm. But neither of those things are actually the question that we should be engaged with. The question is, are these proceedings an exercise of sovereign authority, sovereign power, of seeking to exercise sovereign power? And the reason that the wrongdoing and the mechanism of harm comes into it is because if there is fraud, such as so that the sovereign state has paid out money which wasn't payable as tax, but it was defrauded out of, when it seeks to recover that money, it is not exercising sovereign authority. And that is ultimately the question here. It's not analysing it's not analysing the cause, the wrongdoing and the harm. It's what is the nature of the claim which those matters mean that the sovereign state is bringing.
My Lord, in my submission, and this is why I grounded this part of my submissions in some detail, I hope not tediously, in Solo, is that in my submission is an important question, an extremely important question, but it's not the only question. And I took the court to paragraph 50 of Solo and the three negative tests which we saw. If so, then the court will not determine or enforce the claim. On the other hand, if in bringing the claimant is not doing an act which is of a sovereign character or by virtue of sovereign authority, and the claim doesn't involve the exercise or assertion of a sovereign right, and the claim doesn't seek to vindicate a sovereign act or acts, then the court will both determine and enforce it. And then reading that with 56, it is necessary to look at all the circumstances to see whether in substance
Can we just go back to paragraph 50? Can we get paragraph 50 on the screen?
I do apologise, my lord, that's page 28 of the
28.
electronic transcript. Yes, there we have it, just under conclusions of principle.
Exactly. The critical question is whether in bringing a claim, the claimant is doing an act which is of a sovereign character.
Bringing the claim.
So what we have to say here is when SCAT is seeking to recover money it's paid out on the basis of a fraudulent presentation of the claim, is it acting in a sovereign capacity, or is it simply as a private citizen who has been defrauded?
Yeah.
That is the only question at the end of the day.
It's fairly clear from the passages from Dr. Mann's article that the judge cites in paragraph 68 and 70 what Dr. Mann's view would be, which is that this is not the exercise of the sovereign. It is simply an attempt, albeit by a sovereign authority, to recoup money of which it has been defrauded. Just as in the examples that he cites, such as the New York case. I think there's some more on there. And in the passage on in paragraph 69 of the judgment, where the judge quotes what Dr. Mann said as to the possible explanation being that what's concerned is the reason why it's a commercial or private law claim is because the relevant defendant has acted voluntarily by demanding the money. In other words, if the relevant defendant is not having imposed upon it some sovereign act by a public authority.
Well, on that point, my lord, in my submission, the judge was quite correct to point out that the voluntary nature of the act by the defendant or the alleged wrongdoer can't be the test. Because any act, that wouldn't even map well onto the way that SCAT puts its case. Because SCAT puts its case as depending on not just the act being voluntary, in other words, that the individual has voluntarily brought themselves into the orbit, if we put it that way, of the tax system, but rather that the individual has acted wrongfully or dishonestly. So the voluntary nature of the acts isn't going to be the touchstone even on SCAT's analysis. And as the judge also put it, and we say correctly, the benefit claims and the benefit recoupment claims are an entirely separate thing, and one cannot simply equate those to the functioning of the tax system. And it might assist. I'm conscious of having about, if I'm not going to cut into Mr. Beale's submissions, which are obviously extremely important, I'm conscious of having about 12 minutes left. So I'm going to focus on the most important things I have to say in answering the questions which have just come up.
For my part, whilst of course waiting for Mr. Beale with bated breath, this is at the very core of the Respondents' case.
Yes, and and the question is, does the administration of the tax system stop at the fact that on the wrongdoing side of the equation, there is said to be dishonesty, as opposed to negligence, as opposed to mistake? Does that make all the difference? And does that, and bearing in mind also that this is simply as alleged, so in other words, the claimant need just allege that the mental state reaches a certain threshold of wrongfulness, and can that be the touchstone as to whether, can the alleged gravity of the mental state of the defendant be the touchstone for whether Rule 3 invites a case or not? In my submission, no.
It's not necessarily the only touchstone, but it's a material feature, an important material feature, I would have thought. I mean, I think there's a danger on all sides in this case of everyone saying this is the only thing that matters, and thereby overstating their case. But the idea that the fact that the payment has been procured by fraud is an immaterial feature is not one that I subscribe to at the moment.
Well, I hope I'm not falling into that trap of saying this is the only thing that matters. But what I have been trying to say in my submission is that this is a thing which, firstly, the judge thought mattered. Secondly, that he was right to do so. In other words, SCAT doesn't get home on its appeal by saying that the judge took into account considerations that he ought not to have done because he was drawing on the broader framework of the rule. And that thirdly, and if I may direct the court's attention to where this all bites and where he applies this analysis, is really just 4, in my submission, key paragraphs that make good this point. Paragraphs 110 to 114, and that's at Core Bundle 1, tab 3, page 33. So drawing things together, and I hope I'm not focusing on this to the exclusion of all of us, but focusing on this as simply my contribution to the joint analysis of the respondents. But when one looks at those paragraphs, we see that this is the judge dealing with the fraud case. This is the question of, does fraud unravel all? Does fraud make the difference? Is fraud the thing that unwinds the otherwise sovereign nature of the process of assessing and paying out WHT refunds? And we see at paragraph 11, 110, he gives very careful attention to what's meant by sham here. And I would underline that because the court has seen in Mr. Jones' submissions earlier that the position is rather more complex on the pleadings than simply people filled out documents and there was absolutely nothing to any of these companies, for example. And the judge is very careful to show here that he understands that when one is talking about manufactured, fictitious or sham claims, he understands very precisely what those were, as one would expect of the commercial court judge who had managed the litigation thus far. And he makes it clear that he can see that the primary substance, as he says, of that plea is not that no transactions were entered into, but rather that given their terms and effect, in particular taking the package of transactions as a whole, it did not create such rights or result in any such payments or payment entitlement in respect of dividends as might have qualified for a refund. But then, and this is what we place some emphasis on in answering the does fraud change the nature of the situation point. He goes on at 111 to address what he describes as the closed loops of share sale and share lending transactions. And he notes that whether or not these trading structures gave rise to valid WHT reclaims under Danish law was the central validity issue. In other words, that was to be the subject of the 6-week trial that would have taken place last Michaelmas term, with all the voluminous pleadings of which the court mercifully has only seen a snapshot. And all this, as the judge clearly had well in mind, all those web of determinations stands between the SCAT and the correctness of its simple assertion that there are misrepresentations on the form. But then the judge took it, in my submission, carefully and step by step, through all possible permutations up to the worst possible version of the case. And so at paragraph 113 and 114, they show these paragraphs that the judge was entirely aware of the sham case, or what SCAT also calls the strangers to the tax system point, right up to the strongest version, as he puts it, paragraph 114, whereby the defendants dishonestly pretended to be Danish taxpayers while not in fact being such. So in other words, he was quite prepared to test out his legal analysis against the strongest possible version of the facts. So, and in my submission, the judge's conclusions at 113 to 114 flow logically from the legal principles which he had correctly identified and which I've sought to address briefly in my submissions. He carefully distinguishes, as he was required to, between the wrongful acts and the mechanism of harm. And however SCAT frames its case on why the applications were wrong, these are all, as I've said, permutations on the wrongful acts side of the equation. And it can't matter, we say, for the purposes of the rule, whether the alleged misrepresentations were A, misrepresentations because they were based on disputed propositions, the correctness of which, as a matter of Danish law, was going to take a 6-week trial to resolve, or B, misrepresentations because they were some form of sham, in the particular meaning that the judge has defined there, and that is because they didn't give rise to the acquisition of shares or receipt of dividends within the relevant rules of Danish law. In both cases, nothing about how one characterises the wrongfulness or the state of mind makes the activity of granting refund applications anything other, we say, than a sovereign act.
But then that does then apply to situations where SCAT has paid out to somebody who's just simply stolen somebody's identity.
Not, and as I said, that would depend then on a very, and I think the judge accepted this, it would depend on a very, to use a horrible word, granular or detailed analysis of exactly how that had occurred. This will all depend, as the judge appreciated, on very careful analysis of the facts.
I really don't understand that. If there is a very simple fraud where somebody says, I am A, I'm entitled to the tax refund, pay it to me, and it is then paid to them. And that's a fraud because they're not A, they're X, pretending to be A. There's nothing complicated or granular about that. Is that or is that not? Is the claim to recover that money, is it or is that not an exercise of sovereign authority?
If the assessment of that application didn't involve any evaluation of it or any sovereign analysis of it, then potentially it's not caught by the rule.
But
the judge
says this SCAT was and is acting as the Danish sovereign tax authority in the interest of the Danish fisc. The central interest in the pursuit of which SCAT brings this case remains that taxing Danish company dividends inaccurately. Purely, why doesn't that apply in full, red in tooth and claw?
Well, the judge also correctly distinguished between, and was clear, as I hope this court is, that it's not part of the respondent's argument that it's simply that the funds that SCAT will recover by a claim, or that a sovereign will recover by a claim, will go to the public purse, or will go to the revenue. He was being very clear about that.
I appreciate you don't want to get into detail, and maybe that it's difficult for you, but what about other situations, for example, where a SCAT inputs the wrong account details, so it's correctly assessed that money is due to A, but by mistake it pays it to B.
Well,
can it reclaim that?
firstly, on my Lord's observations, I'm entirely in the court's hands and content to get into any detail that would assist the court, so there's no reluctance on that front. I am mindful of my Lord Justice Stuart-Smith's concern that analogies.
I've got a couple more for you.
I didn't actually agree that they're not. These aren't analogies. These are testing the scope of the proposition.
Other examples in which the proposition which you put to the court is being tested, so they're not analogies. And we don't all necessarily agree with what Lord Diplock said about analogies anyway.
Well, if we can form an orderly queue of analogies, we first have, I'm going to put on my list the mistyping the number. So SCAT, as I understand my Lord's point, or example, this is the SCAT employee who there's a perfectly legitimate refund, and the SCAT employee is typing into the computer and mistypes the bank account, for example, so that the money goes to the wrong person. Is that the question?
Well, that's one possible way, one of many ways in which the money could end up in the hands of a mistaken payment could be made to the wrong person, whereby the tax refund that was due for A ends up in the hands of B. And the question is, does suing B for the money paid by mistake fall foul of dicey rule 3 on the basis that SCAT is then exercising its sovereign authority in the interest of the Danish fisc.
Would it assist if I gather together the examples and if there are any common themes, then I'm simply conscious of the fact that I have, without cutting into Mr. Beale, I have about 2 minutes to finish off the examples.
I'll give you my two because I think they might be helpful. The first is that the respondents hack into SCAT systems so that they generate refunds without any human intervention. The second is that they somehow hack into or compromise their systems so that the system presents an application for a refund to its employees so that they appear to be genuine when they're not. Now, on the submissions you've been making, I suspect that you would say that those two fall on different sides of a line, or may fall on different sides of a line, but I don't know.
I'll say one thing to start with, which is that, by way of caveat, which is that we may now be discussing penumbral examples, which may be illuminating, which of course I'll answer to the best of my ability, but we say that in this case we're not dealing with a penumbral situation, if that's a word. We're dealing with a core situation. We're dealing with a clear example of sovereign acts, and therefore whether or not we can all satisfy ourselves as to where the line would draw, as the judge very fairly observed that he, for example, he might put mistaken identity into a separate category. The judge fairly observed we can't necessarily settle once and for all in this court this afternoon every possible permutation of wrongful conduct and where it would fall on the line, and other courts will have the pleasure potentially of looking at that as cases arise. But with that caveat, mistyping the bank account in my submission, that's not an act of sovereign authority.
But paying.
Yeah, but it's the payment. It's the mistaken payment. That's what gives rise to the claim. And as my lord said a moment ago, what we're focusing on is the claim that's being made in the proceedings. Is the claim that's being made in proceedings a sovereign act or being done to vindicate a sovereign right, however you describe it? Or is it simply the same sort of claim as could be made by a private individual for recovery of damages which they've been induced, recovery of money which they've been induced to pay by fraud or induced to pay by mistake?
Of not managing to get the money that has been assessed as really being due to somebody, to the right recipient, in my submission, is out with the realm of sovereign authority. So in other words, if SCAT, and to put it more concretely, if SCAT, as I suggested earlier, if SCAT took the refunds round in a van and somebody left the keys in the van,
We don't need to go into absurd situations. We could do very, very central situations which an administrative body like this may have all the time. And there may be many different ways in which they end up paying the wrong person, either by virtue of misrepresentation, by mistake, or whatever. And you say you'd have to parse all of these situations very carefully to look at exactly which point it is. But the other side of the coin is, the other answer is, no, you don't. If SCAT pays out money to somebody where they did not have a claim for tax in the first place, then the claim to get that back is not a sovereign act. It is that of any private person who is claiming money which they paid out without good reason, without good cause, mistake, fraud, whatever. And forgive me, but that other side, that argument on the other side of it, cuts out all of your needs to analyse exactly what was done when, and it produces a coherent, logical, legal analysis which answers. You don't need to draw the line. It answers everything.
Looking at this from SCAT's perspective, I'm not sure it would even answer everything on SCAT's case, because on their case, the touchstone is fraud. And so in their case, you have to look at the state of mind of, I'm not sure how it would fit into the mistyping the bank account thing, but I'm not sure that SCAT could, to the extent that it's difficult for me to draw the line here, because it is difficult as at the margins here, I'm not sure that SCAT proposes any test which makes things any better.
Well, I think
Because where would be the
Scott's
fraud?
concentrated on fraud, perhaps for good reason. But I'm not sure that it's right that the presentation we heard yesterday applies only to fraud.
One should never answer a question with a question, but I do consider whether that's correct in light of what we've heard about ED&F man this morning.
Well, that's a different issue. Mistake is the other example that my lord has put.
Well, on SCAT's analysis, if it's a non-fraudulently induced mistake, then that's the touchstone.
Well, I find that a difficult distinction.
I mean, anybody who paid out money by mistake that's recoverable in the law of restitution. And if the tax authority pays out a refund by mistake, is it in making its claim, which you could make as a private person if it were a private person, is it precluded by the revenue rule because that's a sovereign act? So the judge clearly thought that it doesn't deal with mistake, other than mistaken identity. He obviously thought there was some difference to be drawn in the case of mistaken identity. And it seems to me, as I think it does to my lord, that I don't really understand how he draws that distinction.
On either party's case, these examples can only be answered by doing some quite complicated analysis of something, whether it be on SCAT's case, the state of mind of somebody
sorry, Miss
involved.
MacDonald, my Lord Justice Phillips put it to you, it's not complicated. And I entirely agree with him, it's perfectly straightforward. I mean, what we're putting to you is straightforward examples.
If somebody's not entitled to the money, but they're paid the money,
I mean, at the end of the day, fraud is always dressed up as incredibly complicated by the fraudster. But when you get to the core of it, it's usually pretty straightforward. As any judge who's tried a jury trial involving fraud will confirm. Anyway, we've taken you way out of your
Well, my lords, I'm content to continue to explore these examples. I haven't even got onto the computer hacking, but I'm very concerned about treading on the toes of Mr. Beale. Just in one sentence in my submission, hacking into the computer or would be the same as tunnelling into the bank vaults. In other words, doing the wrongful act and getting the money. There's no active sovereign authority there. So they would not fall foul of Rule 3. And if the court is content with that brief analysis, I will simply say for the court's note that I had intended to address two things, which I won't now, but I'll just give references. Public policy exception. We say there isn't one. It's one obiter paragraph in Barakat. If there is, it is very clear that the Court of Appeal there was considering only leaving some flexibility as to other public law cases, and nobody argues that we're in such a situation. And for the court's note, we address this in greater detail. We address this for trial in some detail in our written submissions, and they are at Supplementary Bundle 1, tab 14, pages 21 to 23. I should also mention for completeness, because otherwise it will be said that we have not addressed this, we have a Respondents' notice in which we seek to keep in play an aspect of the comity analysis. In other words, the relevance which the judge did not consider to be relevant of an analysis of what it would actually involve to try the case from the perspective both of characterisation, as my learned friend Mr. Zelek will pick up, and also from the perspective of the paragraph in the SOGO 64 to 66, where they looked ahead at the potential for embarrassment in the trial. I don't have time, without trying Mr. Beale's patience far too far, to develop that orally, but I would simply note that this is addressed briefly in our appeal skeleton at Core Bundle 4, tab 26, page 17, paragraphs 49 to 52. So that is a point that we maintain. And this was also addressed in much greater detail in our submissions at first instance. References for that are Supplementary Bundle 2, Tab 8, pages 29 to 49, and then Supplementary Bundle 1, Tab 14, pages 35 to 38. It's always unsatisfactory just to end on a bunch of references, but in light of the fact it's 8 minutes past 3, I think that is where I shall end, subject to whether there are any other matters in which I could assist the court.
That's very helpful. It's probably sensible if we take a 5-minute break now, isn't it?
That's exactly what I was about to suggest, Mum.
Solicitors coming in after 4:30, doing stuff they did it yesterday. So I said to Tracy, because my trains are so iffy, I said, I can stay, but I can't stay any later than 10 past 5.
Which one are you speaking now?
Time I get out of the train,
Nice.
7:34.
Thank you.
So
Do you want me to do a test?
That's okay, I know, just tested this.
it's past 6. So I've just said I'm happy, so I hope she says okay. So normally what happens if we're over there, like that, one of the associates will come down and I say go, but we can't. They have to do it on the setting day, so they change everything, and then they've got mics on the roof, so they want to do it.
Bring these up.
But they copy in security, so security might be able to sort of, look after it. If I'm there till then, we make it. The thing I'm just worried about is if I go and they're here on their own. Can't they come in on the anyway.
About 2 minutes ago.
I reckon at least 2 minutes.
So when it's like 13 past, then
Yeah.
definitely going over time today.
What time do you want your break?
Should we say half 9?
Come back.
Have you had your break yet?
Don't worry about me.
You sure? Okay.
Yeah.
Is everyone ready? There's still a few people outside.
That's so short.
It's parallel, but we don't.
We've got nothing to do with each other. I mean, jurisdictions within take. What happens? Take.
Are we waiting for anyone? No? Okay.
That's all good.
Are you sure? Would you like that to be there? Got you on. Always feels like a cockpit.
Got rise?
May it please your lords, when I was parachuted into this case at short notice, I think I hadn't probably appreciated it would be quite so far behind enemy lines, but there we are. I have three core propositions, which are set out in my written skeleton. I'm going to summarise what those propositions are, and then I hope relieve your lordships by pointing out that I'm only going to deal seriously with one, lightly with the second, and not at all with the third.
Okay.
The first proposition is that these claims necessarily involve the assertion of a right to recover allegedly overpaid income tax refunds. So the SCAT asserts that refunds were wrongly paid pursuant to a WHT regime which they set. We say, in a nutshell, that the SCAT is with respect wrong to say this is not a claim about tax. They're wrong to say that no tax is due or being reclaimed, and they are therefore wrong to say that there's no unsatisfied claim for tax. The second point is, in essence, the marred point. Our point on that, as my Lord the Chancellor rightly observed, was deployed responsively and defensively to deal with the jury point that, well, this is very unfair because we can't get satisfaction anywhere else. But it does have a broader point, which is that in this case, as I hope to show the court, SCAT chose to flip from a tax assessment procedure into a civil claim in this jurisdiction rather than in Denmark, for reasons that one can surmise were based on the ability to secure a worldwide freezing order against the relevant assets to stop the dissipation of those assets, so otherwise their claim would be nugatory. Be that as it may, and whether or not that involves an abuse, which I'm not going to cover, I do propose to at least point out what alternative route SCAT could have adopted, albeit a broad and high level. My third point was that the SCAT has here exercised sovereign executive information gathering powers when pursuing its claim. And that was pages 19 to 20 of my skeleton, and I propose to leave that in writing. Now, before fully developing the necessary statutory background and the legislative scheme, I would like to highlight 2 points my learned friend Lord Panic wisely recognised yesterday. The first, with which I respectfully agree, is that Lord Lawrence Collins knows a thing or two about this subject. The second is that it is said that the Sunico case is closely analogous to this one. Now, we say, in fact, an immediate point of distinction with the Sunico case is that there is indeed a relationship between the SCAT and the WHT applicants here. Now, true it is that application is as a result of an application process. True it is that results in a process has arisen as a result of the WHT applicant's conduct. But we say that is a distinguishing feature from Sunico, where there was no direct relationship between HMRC and the people who had perpetrated a fraud on UK VAT. And of course, the Sunico case involved a claim before Mrs. Justice Proudman, where HMRC brought the litigation in this jurisdiction. And it relied on jurisdictional gateways to bring the alleged fraudsters, found to be fraudsters, into the jurisdiction. So we're in a position where Lord Collins is frequently right, and Sunico is a close case. Could I please invite the court to look in Supplemental Respondents Authorities, Bundle 7, tab 68, starting at page 1. We have there on the screen the Law Quarterly Review article written by Lord Collins, as indicated at page 4. It's called The Enforcement of Foreign Revenues. He's dealing with the Sunico case. On that first page, sorry, you've gone to page 4, but I really didn't need to. Back to page 1, please. Oh, that is page 1, sorry, yes. Halfway down, one sees in litigation in England, which is the subject of this note, the revenue claimed that a Danish company, Sunico, had been party to a fraud in the supply of mobile phones, and that the revenue had been deprived of about £40 million in unpaid VAT. As an intra-EU trader, Sunico itself had not been liable for the VAT, but it was alleged to have been part of a fraudulent conspiracy, and it was ultimately held to be such by Mrs. Justice Proudman. One then sees that one of the questions was Brussels regulation. I'm not going to touch on that, but if we could turn, please, to page 2, one sees in the third paragraph down on that page a section that begins "the reasons were these." This is confirming that the CJU and Advocate General Cocotte in the Sunico case found that it didn't fall within the Brussels regulation, but part of the reasoning is relevant. The reasons were these. The action by the revenue against Sunico was based not on UK VAT law, but on Sunico's alleged involvement in a conspiracy to defraud, which came under the law of tort. Sunico and the other non-residents sued in the English High Court were not subject to VAT in the United Kingdom and were therefore not liable to pay VAT. In that action, the revenue did not exercise any exceptional powers by comparison with the rules applicable to relationships between persons governed by private law. And that, in a nutshell, is characterising the debate in a way that will be very familiar to this court after nearly 2 days of argument. We then see, in the 5th paragraph, a paragraph beginning, "This is a surprising result." And the reason why Lord Collins reached that conclusion was that the test for what amounts to a civil or commercial matter has no direct equivalent in the English conflict of laws, but the rule in England is that the English court will not allow a claim for the direct or indirect enforcement of a penal, revenue or other public law of a foreign state. And no doubt if an English court were considering an action by, say, the Irish government in a similar claim against the English company, it, i.e. the English court, would regard the claim as being an inadmissible claim for the indirect enforcement of foreign taxes. So Lord Collins is recognising that fraud is not the dividing line between whether or not something falls in or without the Revenue Rule 3, the Revenue Rule in Dicey Rule 3.1. So Lord Collins is saying an English court would. There's no equivocation. This is not something that he's saying, well, of course, it could be open to argument. He's saying they would. You would walk straight into Dicey Rule 3.1. So it's a fraud case. It's a fraud case that deprives, in this example, the Irish revenue of VAT. It's Irish VAT. The suit is brought in the UK English courts for the sake of argument. It's a claim to recover VAT that's been wrongly paid out because it was the result of a fraud. And Lord Lawrence Collins, I beg your pardon, says in terms that would walk straight into Dicey Rule 3. Now he then goes on, if I may say so, at page 3, to deal with the Pascotino case and some of the US jurisprudence. And so one sees a summary. If your lordships perhaps would be kind enough to cast an eye down the entirety of Rule 3. He's giving some background to claims that were brought initially by Canada and then by the European community involving fraudulent activities, in this case corrupt activities under RICO, conducted by smugglers, by which the fisc of either Canada or the European Union has been deprived of revenue and tax by smuggling activities. Now, to cut to the chase, there was a consistent line of case law that said attempts to rely on the RICO statute to secure the recovery of excise duties dissipated through fraud would be caught by the revenue rule. There was then the decision my learned friend Lord Panic referred to in Pasquotino, where the Supreme Court, in the ratio of that case, said that where in fact what's being relied upon is a domestic statute criminalising domestic conduct in the United States, and the United States chooses to enforce it, the fact that the ultimate loss is suffered by Canada is irrelevant. And we see that ratio is reflected in the paragraph that begins, the EC then presented a petition of certiorari to the US Supreme Court. And Lord Collins describes the ratio as being, it was decided by a bare majority that the revenue rule did not bar a criminal prosecution by the United States and conviction for the federal offence of wire fraud in connection with a scheme to smuggle alcohol into Canada to avoid Canada's import taxes. The essence of the decision was that the terms of the statute clearly applied to the conduct alleged, and it was not subject to an implied reservation. So, in short, construing the Wire Fraud Act in that case, the actus reus was conducted in the United States. That was found to ground the criminal liability, and the fact that it was a fraud that was perpetrated on a foreign-friendly power didn't stop the prosecution being brought. Now, in contrast, there was a footnote in that case, which we can turn to relatively straightforwardly, I hope. It's in the Supplemental Appellants Authorities, Volume 2, and it was the inserted tab 11.1. And if we could turn internally, this now has pagination, it didn't, I'm afraid, when it was given to me. If I can add, please, 5 pages, so we go to page 5. I hope that's internal 779. I'm sorry, the next page there. Yes, one sees there a footnote 1. The ratio is, as I hope I've simply summarised. We express no view, this is the majority, on the related question whether a foreign government, based on wire or mail fraud, predicate offences, may bring a civil action under the Racketeer Influenced and Corrupt Organisations Act, which I've called RICO, for a scheme to defraud it of taxes. It's then that some of the case law is then cited, including Republic of Honduras and Morris. Now, the ratio from Republic of Honduras and Morris can be found in the Supplemental Respondents Authorities, Volume 5, tab 46. And what proposition is this going to? This is going to a proposition that the revenue rule catches tax of another state that has been obtained by fraud, and it still falls within the scope of the revenue rule. Now, this was a decision of the 11th Circuit, which is Georgia, Alabama, and Florida. It was a decision that took place prior to Pascatino. At page 6, please. We see that there's recognition that recasting the claim as one for fraud does not dispute the fact, or cannot dispute the claim that was in substance one for unpaid taxes. We see little f h. Furthermore, the revenue rule applies regardless of whether republics frame their damages as the direct loss of tax revenue or the indirect effects of such tax loss. So what one finds is that all of these fraudulent schemes involved schemes to avoid paying taxes and seeking to collect these unpaid taxes, and it was the fraud claim by which the unpaid tax was being enforced. Now, obviously, Pascatino was a decision of the Supreme Court. It was a decision that reconsidered the revenue rule in the context of a criminal prosecution. But nonetheless, there was then an application for a petition in the Nabisco case involving the European Community's claim for lost excise duty on smuggled cigarettes. And what one sees is that there was a remittal essentially back to the same court that had found that claim would fall within the revenue rule, and they were asked to reconsider whether or not the Pascatino decision made any difference. Held it didn't. This can be seen in Supplemental Respondents Authorities Bundle 5, tab 49. And if we could pick it up, please, at page 4.
So this is the Second Circuit, which is New York.
This is the Second Circuit, New York, yes.
New York,
Connecticut, New York, and Vermont.
It's mainly New York, isn't it?
And I think
I think New Jersey and I can't remember where else.
so. The presiding judge at the time was Justice Sotomayor, who I think is now Supreme Court Justice. What one sees at page 4 is some of the procedural history, starting with the plaintiffs appealed to this court. It confirms we held that the revenue rule barred the foreign sovereigns, that's treated as the EU for these purposes, civil claims for recovery of lost tax revenue and law enforcement costs. We affirmed the judgment of the district court on the revenue rule question, and the plaintiffs filed a petition for a writ of certiorari from the Supreme Court. There's then a summary of the issue in Pascatino, where it said the Supreme Court specifically declined to express a view as to whether a foreign government, based on wire and mail for predicate offences, may bring a civil action. So that's the footnote I took your lordships to. Please can we then look at page 5. And please could I then invite your lordships to read the paragraph that begins the revenue rule and civil RICO claims halfway down the page. Turning over the page at page 6, subparagraphs D to F. They indicate, certainly from the US jurisprudence, what the primary concern has been, which is articulated as the policy rationale behind the revenue rule. One can simply cast an eye over that. We have obviously had slightly differing.
Sorry, where are you starting?
Subparagraph D, my lord, D through to F, if I may.
Thank you.
Starting, we stressed in our opinion.
Thank you.
Could we then please move to page 7 and the bottom of page 7? In contradistinction to a claim being brought by the United States under a US domestic statute, the present civil law suit was brought by foreign governments, namely the European Community. Moreover, the executive branch has given us no signal that it consents to this litigation. That was obviously a separation of powers issue, needn't detain us here. Could we then please turn to page 8 and the bottom of the page again? In a potentially career risky move, they suggest that the Supreme Court's language in Pascatino is not entirely clear. But they then say, but the whole object of the present suit is to collect tax revenue and the costs associated with its collection. Thus, under any of the available formulations of the revenue rule, plaintiffs' claims are barred. Could I then please invite you to read the rest of page 9? Actually, we can, I think, cut to the chase, as we held in Canada. You can focus, please, on that paragraph halfway down the page. And if I could invite, please, the court to read that paragraph from D through to F. That, I think, is all I need to say. Now, the reason why we suggest, with respect, that line of authority is relevant is not simply that Lord Collins has chosen to refer to it in the same breath as dealing with Sunico, but also it makes very clear that fraud is not the answer. And therefore, my learned friend Lord Panic's recognition, quite rightly on day one, that fraud is not the answer, is necessarily right. Now, quite a lot of your lordship's questions have been geared towards, surely fraud unravels everything and it takes away the basis for the tax assessment in the first place, and therefore it's not a claim for tax. I'm afraid that the answer to that, simply put, is that's not right. And one can think of any number of examples in the VAT context where a claim for a VAT refund has been fraudulently induced. And the suggestion that if HMRC seek to enforce that in the courts of another state, that wouldn't still be a claim for tax, I'm afraid, would fall straight into the Rule 3.1 analysis. Imagine, for example, that I've been a thoroughly naughty barrister, and that I'm called in both Ireland and the UK, as I am in England and Wales, and that I have manufactured invoices on which I am claiming chambers expenses. and that I present both those invoices in mitigation of my tax debt under the income tax statutes of both the Republic of Ireland and the United Kingdom. That would be a claim that was premised on an outright fraud. That would be a claim that both authorities would be entitled to deny under their respective tax regimes once they found out about it. If in the meantime they had given me a substantial credit against my income tax liability or against my VAT liability, then that would be a recognition of a claim for a refund, in that case of VAT, or a claim for a credit of income tax, which would redound to my benefit, and it would redound to my benefit wrongly. If the Irish Revenue chose to enforce that wrong payment, that fraudulently obtained payment, assume for the sake of argument I get money back from the revenue because it's a VAT claim and I've made no earnings in Ireland and therefore I'm what's called a repayment trader. I get my claim for VAT back from the Irish Revenue. If they choose to enforce that against me, not in Ireland, but in the United Kingdom, in a civil action, saying, well, this is all based on fraud unravels everything, then the answer would still be, I'm afraid, but it's a tax that I've wrongly claimed from the Revenue. The Revenue were exercising their sovereign executive powers when they made that payment available to me because it was part of a tax regime, and that brings it within the scope of the Revenue. And you have clear and consistent authority from two different circuits in the United States, endorsed by Lord Collins, that would support that analysis.
That's quite a different situation, though, and one thing one hasn't looked at all in any of the debates is where there is an ongoing tax relationship, including possibly you might regard it as a tax account. And so you could regard an overpayment of a refund or an refund as a credit or a debit on what is effectively a running account between a trader with a VAT number and revenue. I think I'm not sure that does undermine the argument that where somebody who has no relationship at all with the revenue fraudulently obtains a payment from them which just simply goes into their bank account and never to be heard from again. I'm not sure that is the same thing at all.
But my lord, that is the example of Sunico. Sunico had no direct relationship whatsoever with the revenue here. They had obtained through a conspiracy to defraud sums that were representing UK VAT, properly due in the UK. The person who had defaulted for UK VAT purposes had disappeared into the ether in the standard way with carousel cases. Whoever's at the top of the chain disappears as a missing trader. That's why it's called missing trader fraud. And the exporter at the bottom of the chain who has recovered the input tax could be denied that input tax under domestic authorities such as Kittel, endorsed by this court, ECJ authorities such as Kittel, endorsed by this court in the Mobilex case. And what both those cases establish is it's open to the revenue in that situation, even though the fraud is a distance away from the person who is claiming input tax. If the person who's claiming input tax knew or should have known that that tax was intimately connected with a fraud, then that explains why the revenue is entitled to deny their own taxpayer the input tax credit. And that's one way of recovering the fraud. If you think you can't establish against the exporter that they have been party to the fraud because they're the patsy who's simply left with a repayment claim at the end of a long chain, then the only option available to the revenue is to pursue the Sunico route. And that is to sue the perpetrators. If you can get them into this jurisdiction, you sue them in the United Kingdom. And you sue them for the tax loss, even though they are strangers, in inverted commas, to the tax system in the United Kingdom. And that is the Sunico case, which Lord Collins has indicated, if it were brought by the Irish Revenue in the English courts, would be met by a Dicey Rule 3 objection. So
what can we place on that?
Well, my lord can place whatever weight you think is appropriate to place on an extrajudicial observation.
Didn't hear argument on it, did he?
I'm sorry, my lord?
Lord Collins didn't hear argument on it.
No, but there was no equivocation in his view. I'm simply, I'm afraid, going to repeat what Lord Paddock said, which is he does know a thing or two with respect about this area.
Well, we accept that, but as my lord says, there's a world of difference, even with as eminent a lawyer, as Lord Collins says, a world of difference between an academic article written by an academic lawyer and a Court of Appeal hearing 3 days of argument, a detailed argument on the same point. So
Can I make then?
there's a limit to how far you take that point. I mean, I follow your argument based upon the American authorities.
Well, my lord, there it is. Can I also say that fraud has been recognised in cases such as Buchanan not to be a reason to disapply the revenue rule, and I think it's expressly referred to in the judgment itself, Mr. Justice Andrew Baker below, where he recognised that Mr. Feely, who was presenting the case there, had not suggested that fraud was the answer. So one needs to bear in mind that the revenue rule must necessarily apply equally, in my respectful submission, to an allegation that tax has been paid by mistake, induced by an error on the part of the authority, as in situations where that error is the result of a fraudulent inducement. Because otherwise you are riding roughshod over the accepted principle that fraud ultimately makes no difference. What actually matters is what is the nature of the claim that's being advanced, and is it the indirect enforcement of a claim to tax?
Yes, I'm glad. But fraud isn't the answer. Fraud is simply one of possibly a number of reasons why it wasn't an overpayment of tax.
Yes, I mean, it could equally have been a mistaken payment. To give your lordships another example of a decision in this court, Lloyd's banking case, there were a series of very old claims for VAT as a result of change of VAT liability from a CJU decision. And there had been a series of corporate groups, one of which was Lloyd's Bank, one of which was Standard Chartered, became Standard Chartered Bank. And they were vying for who had the entitlement to the claims, very old claims for input tax. And in that case, in fact, there was a factual permutation in one case where the revenue had paid out both of two competing input tax claims. And as Highlander teaches us, there can be only be one. So the revenue had got things wrong. They had paid out twice. They needed to work out which horse they were going to back. They did. They revoked the previous decision to pay out and sought to recover it. And they went with the one that was then in issue. But you had two taxpayers, both legitimately non-fraudulently seeking the same input tax. And it had to be resolved. But it was resolved by the executive, which had wrongly refused the input tax claim, deciding which of the two applicants were going to meet the criteria for repayment. Now here, obviously, it is the entire nature of the dispute that there are multiple applicants for the same withheld income tax that is the subject matter of a refund. And what I propose to do now, with the court's permission, is to show you quite how those applications were dealt with under the legislative framework, and how they were then processed by the SCAT, and how the SCAT took a public law decision to make the refund, and then how it took a public law decision to revoke that decision and claim the sums back. Now, if I may turn to that, the first part of the proposition involves looking at the WHT Act itself, which rather unusually we haven't considered directly until this point. It's in Supplemental Respondents Authorities, Volume 7, tab 58. And can we turn please to page 2? Page 2 has section 1.1 of the Withholding Tax Act, and we see that there's a general requirement for income tax to be paid to the Danish state in accordance with the provisions of this Act by persons who are residents of Denmark. Could we then please move on to page 3? In addition, persons who are not covered by section 1, i.e. persons who aren't resident in Denmark, are also liable to pay income tax to the state if the person or estates in question, and then at the bottom, subparagraph 2, strictly speaking, carry on a trade, for example, with a permanent establishment in Denmark, so you can be non-tax resident, but with a permanent establishment, which gives rise to a tax nexus. And then please, page 4, subparagraph 6, highlighted section, tax is also imposed on obtaining dividends comprised by relevant sections of the Danish Tax Assessment Act, applying by analogy. So it's also imposed on people who obtain dividends. If we could then please move on to page 11. We then see at the bottom of the page in the highlighted section that the income tax that's levied on those dividends shall be 27%. However, income tax amounts to 15% of the dividends if the competent authority of the state in which the person is resident must exchange information with the Danish authorities according to a double taxation treaty and other international agreements. So you have the broad imposition of tax at 27%, but an exception then bringing it down to a level of 15% for standard DTA cases. Can we then please look at page 13, section 65. This is the withholding part. So having established a charge to income tax, 27% of any dividend, and it's payable by foreign persons non-resident in Denmark, we then have the mechanism that charge to income tax is withheld at source. Section 65(1) says, in connection with any adoption or resolution to either pay or credit share dividends, the company or association in question must withhold 27% of the total dividend unless otherwise laid down in pursuance of subsection 3 or as follows from subsections 4 to 6. 4 to 6 and 3 are not relevant here. So that imposes the overall obligation. We then see at page 21 the relevant provision by which the refund was claimed. And would the court be kind enough to read, please, the whole of page 21, starting with 69B1 itself. Now is an appropriate time to flip to the bottom of the page. I think that's probably it in any event. It is, so we don't need to flip. The curious thing about withholding tax is that it gives rise to some pretty well-known problems in terms of international taxation and indeed as a matter of domestic taxation. The domestic taxation problem is that you have, or could have, economic double taxation. How does that arise? Well, you have a corporation tax charged by a company on the profits it makes. With the money it has earned, it then pays out a dividend to its shareholders. And a tax on the dividend, therefore, in theory, covers both sets of income, unless you somehow allow a credit to the company for the dividend that it has posted to its shareholders. That's the way you can avoid domestically economic double taxation. Now, the other problem that arises is where you have a dividend that goes cross-border. Because there you might have, as here, the paying or host state taxing the dividend payment itself as a source of income, and its territorial tax system says this income has been generated and is paid in Denmark. And then the receiving state may say, oh, well, it's being received in the United States, and we're going to tax the receipt of the income from that dividend also. So you have this juridical double taxation where you have two different taxing authorities asserting an entitlement to tax. Now, the way that that second issue, juridical double taxation, has been dealt with is through a series of double taxation agreements concluded by most Western democracies, certainly. And most of those follow the OECD Model Tax Convention, which, for your Lordship's note, is at PA 10, tab 96. I'm going to cut to the chase, though, and turn simply to an example of the US-Danish Double Taxation Convention, which is in Supplemental Respondents Authorities, Bundle 7, tab 60,
US or UK?
US Denmark.
Thank you.
I'll give my lord. The note for the UK Danish DTA is Bundle 7, tab 63, but it's in very similar terms. I'm going to go to the US one, partly because the documents I'm about to turn to involve the US DTC. Sorry. Article 2, page 7. So this is tab 60.
Need to get it on the screen.
Tab.
This is tab 60 of SRA 7.
Thank you.
Page 7. And should have Article 2, taxes covered. So the scope of the DTA covers income tax to the state in Denmark. And we've seen that's what the Danish tax is doing. It's imposing a charge to income. If we turn over, please, to page 8, there is a formal definition of residence. Suffice to say, resident of contracting state generally follows well-recognised principles. There's usually a tiebreaker, there is here. If both are asserting residence, it's to be dealt with by mutual agreement. Page 14, Article 10, deals with the payment of dividends. And what this says is, under subparagraph 1, dividends paid by a resident of a contracting state to a resident of the other contracting state, so just pausing there and inserting it, Danish company shareholder in the US, that is caught by this, may be taxed in that other state, so they may be taxed in the US. However, under subparagraph 2, such dividends may also be taxed in the contracting states, which the company paying the dividends is resident. So Denmark can tax this according to the laws of that state. But if the beneficial owner of the dividends is a resident of the other contracting state, the tax so charged shall not exceed, under subparagraph B, 15%. And so that is why we've seen the restriction to 15% for appropriate DTAs, and this is such a DTA. And lordships will be familiar with the fact that some of the cases have involved not simply a wholesale exemption for pension funds, which is dealt with under subparagraph 3 on this page, 3. B. There is somewhere, I'm sure, a pension fund exemption under one of the DTAs. I can't immediately see it there, I'm afraid, but that's the basis upon which some of the cases have been dealt with as purely exemption cases. But we then see in over the next page, page 15, subparagraph 5, dividends as used in this article means income from shares or other rights, not being debt claims, participating in profits, as well as income that is subject to the same taxation treatment as income from shares by the law of the state of which the payor is a resident. We then can see at page 26, under subparagraph 7 of Article 22, most of Article 22 deals with benefits and who's entitled to them, and it identifies to what extent a company will be a beneficiary. But we then have this catch-all provision. A resident of a contracting state that is not entitled to the benefits of the Convention under the provisions of the preceding paragraphs shall nonetheless be granted the benefits of the Convention if the competent authority of the other contracting state so determines. And my submission to your lordship,
Where are you?
this is at the bottom of page 26,
Tab.
paragraph 7.
Paragraph 7.
Thank you.
If an application has been made to the SCAT, as it has here, and the SCAT has determined that the applicant is entitled to relief under the Double Taxation Convention, then that is an exercise of sovereign public authority power, which recognises the claim that is being asserted. Now, that claim may be wrong. It can be wrong for a number of reasons, which can include fraud, for the reasons I've explained. But it doesn't denude the actual power that is exercised as being an exercise of sovereign authority. Could we then please move on to Article 27, very briefly, page 31. In short, here, administrative assistance is available, but it's available essentially once the tax liability has been finally determined in what I'm going to call the host state, here Denmark. So if Denmark has finally determined the tax liability, then it can then seek administrative assistance. We then see at page 32, overleaf, subparagraph 9. Each of the contracting states shall endeavour to collect on behalf of the other contracting state such amounts as may be necessary to ensure that the relief granted by the Convention from taxation imposed by the other state does not inure to the benefit of persons not entitled thereto. So there's a built-in mechanism by which you can still claim administrative assistance, even if you've got it wrong. And I emphasise again, the reason why you've got it wrong is not material to a principled application of the revenue rule. Because fraud in this context does not unravel everything, because otherwise, with respect, the House of Lords could not have endorsed the decision of Mr. Justice Kingsmill Moore in the Irish jurisdiction in Government of India and Taylor. That was a fraud case. It was a fraud perpetrated as counsel for the taxpayer conceded. That was a fraud perpetrated on the Scottish revenue to deprive them of the objective retrospective imposition of tax, which was found not to be a reason not to recognise the claim. But what couldn't be recognised, even though it was derived from fraud, were the steps that had been taken by the liquidator to indirectly enforce the Scottish Revenue's claim for tax. Now, that was an indirect case because it wasn't the state that was bringing it. We have the advantage here that it is the state that's bringing it, and therefore that part of the indirect assessment doesn't trouble us. The way that indirect versus direct comes in here, and I'll make this good in a moment, is that a direct tax claim is being pursued against those WHT applicants who have been recognised to be applicants and who have had refunds paid to them. And there's a category of persons identified in paragraph 5D of the fourth amended particulars of claim. For my Lord's note, that's Core Bundle 1, tab 4, page 6. But that category of defendants, I think there are 7 of them, are denoted specifically as being WHT applicants. So for those persons, this claim is a way of saying we want our money back. We gave you the refund wrongly, and you were party to a fraud. And the bit about being party to the fraud is the rationale, in a sense, why the claim is there. It's a reason why it was wrong, but actually what is being done is the direct enforcement of a refund claim for tax. The second aspect, so that's direct. The indirect aspect is when one goes against advisors, persons who are ancillary or accessory to the actual tax claim itself, on the basis that they were also party to the fraud, but that doesn't, in my respectful submission, change the underlying substance of the claim that's being brought against them. Otherwise, you couldn't have cases such as the Sea-Train case where Lord Denning recognised that a claim for cargo, detention of cargo, which was being used to alleviate a US tax debt, that you couldn't masquerade a US claim in these courts by saying, well, all we're doing is seeking to detain and have delivered up to us the cargo that's been impounded. And it was held very clearly you can't do that under Revenue Rule 3. That's the Braco and Sea-Train case. Now, can I then please explain why, in this particular case, the terms upon which Denmark chose to make available refunds to applicants was entirely within its gift. Your Lordships have at page 7 of my skeleton a reference to the Gaster Berliner case, and can I, without turning to it, simply point out that paragraph 37 of that case, the Court of Justice made clear that where, as in this case, we're not within the soft harmonisation for withholding tax regimes that otherwise exists, it was open to Denmark to set the terms of the DTAs it entered into and to deal with any economic double taxation. So that the regime that they put in place was entirely of their own choosing. And the way that they chose to enforce it was entirely in their own choosing. And can I draw together some threads as to what Denmark chose to do? Firstly, Denmark chose to tax dividends paid by Danish companies. My Lords, one couldn't have a clearer example of the exercise of a sovereign authority than the imposition of tax. That's why one doesn't need to get into, for these purposes, the whole penumbra of public law powers that have been considered under the equivalent to the revenue rule. This is the revenue rule because they chose to impose tax on Danish companies. The second part of the sovereign exercise of power was to charge 27% income tax on those dividends. The third part was to withhold that tax at source. In other words, Denmark collected up front the tax in respect of the dividends that had been paid or credited, and that amounted to imposing a charge to tax on an income stream. Now, it could have chosen to impose a 15% flat rate corporation tax for all, and then levy an additional charge, taking it up to 27% in those cases where there was no DTA obligation. It didn't do that. It chose instead to levy a 27% charge to tax all round, and to allow applications for refunds to bring it back down to 15% or 0 if there was an eligible pension fund that fell within the scope of an exemption. Now, as we've already seen in the relevant part of the Withholding Tax Act, Section 69B, Denmark also chose to say that they could review the applications, that they could suspend a decision until they had sufficient information to be able to pay out on them. It could require proof to be furnished. And in cases of doubt, it could ask for security to be provided to make sure that they were doing the right thing. What I think the Land Friend Mr. Jones didn't have time to take your lordships to was a sample application. That's in Supplemental Bundle 1, tab 1, page, starts on page 1 itself. That's Supplemental Bundle 1, tab 1, page 1. These are AccuPay documents and they relate to the ARIA pension fund. The ARIA pension fund, I think, was claiming an entitlement to an entire exemption, but I'm not going to get into the weeds on that. Page 1, what one sees is AccuPay submitting a series of forms, one a claim to relief from Danish dividend tax. So they're saying, under the DTA, I have an entitlement. In fact, it's a matter of Danish law, because Danish law has incorporated the DTAs into its domestic regime. One power of attorney between the beneficial owner and AccuPay, 2 original dividend credit advices, and 1 copy certificate of residence. The certificate of residence was to prove that the applicant was tax resident in another jurisdiction. We then see at page 3 the dividend credit advice, and the gross dividend and the net dividend is identified, and the payment date is identified. And it was said that that payment represents the dividend for a company. As my friend Mr. Jones said earlier, this isn't a case where the companies didn't exist and the dividends didn't exist. This is a case where, if I'm putting it crudely, the allegation that's made in terms of the fraud is that a lot of other people came along and said, me too, in relation to this particular dividend payment. So you have 15 or 20 or 50 or however many it is applicants for the same relief on the same pot of money in exactly the same way you frequently get in carousel frauds, where you have a series of people claiming input tax on the basis of a fraudulent conspiracy, and it's the tax going around in a circle. So it's obviously their case, not my case, that is what happened, but that seems to me the best way of analysing it. So as a result of this application, we then see at page 6 a certificate from the Department of the Treasury, IRS, certifying that the above entity is a trust forming part of a pension, profit sharing, and so on. That was relevant in order to trigger a claimed entitlement to an exemption from dividend tax, full stop. Now, what then happened is that the SCAT decided to pay out on a number of those applications. There came a point in time, however, at which it realised that not all of these applications were sound. And one can track this through in the provisional decision at page 1 of tab 2 of the same bundle. So this is Supplemental Bundle 1, tab 2, page 1. And my friend Mr. Jones did take you briefly to this. As he foreshadowed, I'm proposing to dwell on it, if I may, a little. Picking it up, please, at page... I've got the wrong one, sorry. Flip into the update overnight, if I may. So page 1 is now the certified translation. Page 2 is the first page of the decision. Could I invite the court to note, please, this is a decision that is being served by post, one assumes, on the ARIA pension plan, top left-hand corner of that page. If we just move up, please. Thank you. And coming down, draft decision. reclaim of refunded dividend tax. SCAT proposes that ARIA repays the previously refunded dividend tax totaling X. And it identifies what those relate to. One then sees at the bottom of the page, the information shows ARIA is a new pension fund. We don't think you've got the capital to have been able to buy these shares. Last two paragraphs, SCAT thus finds that ARIA did not have the required capital to make the investments. Therefore, ARIA cannot be the beneficial owner of the Danish shares. That, in a nutshell, is the tax validity issue. Is it right under Danish tax law that this entity was not the beneficial owner of the Danish shares and therefore didn't have a valid claim for the refund? We then see, hence, ARIA does not meet the conditions for getting a refund of withheld dividend tax on Danish shares, and it cross-refers to Article 10, which I've taken my lords to, in the US-Denmark DTC. Turning to page 3. SCAT therefore refunded the stated dividend taxes to ARIA on an incorrect, wrongful basis. I interject, it doesn't matter if it was fraudulent or wrong. And I'm afraid that's why there's no blue sky between the EDF and MAN and allegedly fraudulent applications when dealing with the underlying executive decisions that are being taken. Next paragraph, SCAT therefore reclaims the previously refunded dividend taxes according to the rules stipulated in section 69B. The reclaim of amounts paid is generally covered by the 3-year limitation period. The limitation period is calculated at the earliest from when the creditor could demand that the claim be fulfilled. Now, just pausing there, what does that show? That shows, my lords, that SCAT is treating itself as a creditor. The debtor is the pension fund. The debt arises because the entitlement to the refund has been wrongly granted, and it's clearly a recognised cause of action. Otherwise, SCAT couldn't point to the expiry of a limitation period. So what this is teeing up, as one sees, what they're doing is saying, we've got this claim, we think we're still in time, we're going to bring it, but in accordance with standard public law principles, what they're doing is inviting the pension fund to make any representations. And what we then see at the bottom of the page is a reference to a statement of claim. So this is clearly saying this is our claim. At page 5, there's a background to what is described as the resumption. Can I try and explain the resumption, because it's a little confusing? As I understand it, they aren't simply saying we have refused a particular refund application, these are our reasons for refusal, although in fact they have done that. They're also saying, and we're also going to open up for review the previous refund applications that we've made. And what one sees halfway down the page is that SCAT had contacted from, at some point between August 2015 and February 2016, and possibly May 2016, they had corresponded with the IRS, exercising their mutual assistance powers to request information specifically from the US so that they could bring the claim that they're now bringing. And one sees at the bottom of the page, based on the information from the IRS, SCAT resumes, i.e. is reviewing ARIA's previous request for dividend tax refunds, where ARIA has received a refund of withheld dividend tax on Danish shares. So there are two particular aspects to this. Firstly, they are refusing or rejecting the application that is the subject matter of this specific decision. And secondly, they're saying we're also going to open up the previous ones. We then see at page 6, under paragraph 1.4, itemised the list of previous refunds by reference to the Danish shares that are held, the total dividend that has been paid, and the dividend tax that's been refunded. And that is itemising the claim against this particular pension fund for recovery of the overpaid tax. Page 7, further information from the IRS. Page 8, we see the rules of law. So like any good public authority decision, it's identifying the statutory basis for the decision that's being taken. And we see that that statutory basis is a combination of the Danish Corporation Tax Act, the Danish Tax Assessment Act, the Withholding Tax Act that we've looked at, and the Danish Limitation Act. So it's relying upon statutory powers that go to tax assessment in order to formulate a claim that they recognise is subject in principle to Danish limitation periods. It then refers expressly to the Double Taxation Treaty, and it refers to both Articles 10 and 22, that's at the bottom of the page. You'll recall that Article 22.7 was the one I took the call to, that says if the competent authority of the host state, here Denmark, chooses to recognise an entitlement to double taxation relief, then that is going to be grounds legally for the grant of double taxation. And we see at the top of page 9, there is a contested point of law as to whether or not dividends payable on lent shares are only capable of being taxed by the lender, and therefore anyone else who isn't the lender, even if they're a beneficial owner, has no entitlement to reclaim, which is a matter of Danish law. And that is what the validity trial is scheduled for many weeks for, to determine in, I'll be told if I'm wrong, 2023, I think. You then see expressly at page 9 the legal basis. And this is the legal basis for the claim that is being asserted, and it's a combination of domestic statute plus the double taxation treaty. Bottom of the page, please. The reclaim of amounts already paid is generally covered by the 3-year limitation period. So what one sees is an assertion of a legal entitlement under Danish statutory law to recover sums that have been wrongly paid out by way of a refund of income tax. In particular, page 11, paragraph 3.4, they object to the certificate that's been provided saying we are a pension fund resident in the States as being determinative of their eligibility. Finally, if I may,
Where's that?
that's the bottom of page 11. 3.4 pension fund, they don't like the certificate that's been furnished. They could not have liked that certificate when it was presented for the application. They didn't like it. If they thought it didn't pass muster, they could have rejected it. Page 12, one sees at the top, SCAT therefore proposes RA repay the refunded dividend tax as the information received indicates that essentially it cannot be the beneficial owner. The refund's been made on an incorrect, wrongful basis. We want our money back. Now, one then sees, page 13, the opportunity for the taxpayer to be given an opportunity to make submissions, either in person or in writing. And we see that the letter has been submitted. First line under laws and regulations, etc. The letter is submitted on the basis of section 19 of the Danish Tax Administration Act. Now, we're not obviously in a position to go through and understand, and nor did the judge consider it was necessary for his decision to work out precisely what the legal basis was for the assessment procedure that the Danes decided to adopt. But on any view, this is communicating the fact that unless persuaded otherwise by representations, SCAT's intention is to treat the refund application as wrongly made and to demand, you asked for it at the moment, proposing it be repaid, but to demand in due course that it be repaid. That demand is dealt with at tab 3, page 1 of this bundle. So SB1, tab 3, page 1. The bulk of the decision, I think it's fair to say, reiterates the reasoning that's already been given. What it does do is it feeds in comments from the taxpayer, from the pension fund. One sees that at page 13. And it responds to those at page 60. But all of that goes to whether or not it's a valid claim to a refund and whether or not they're right, therefore, to threaten to revoke it. But what the decision actually does at page 2, if we could flip back, please, is to revoke the previous public law decision that's been taken to grant the application for a refund. And again, they're relying upon statutory legislative powers identified in the decision as the basis for that revocation. Now, true it is, if one looks at page 3, bottom paragraph, there's a section halfway down the screen at the moment where it says ARIA has therefore failed to document that ARIA meets the conditions for getting a refund. Well, that's the contested issue for the validity trial. We then see, third paragraph up from the bottom, in this decision, SCAT does not collect the incorrectly paid dividend tax fund. This is a change in relation to our previous decision, so the draft decision. On behalf of SCAT, the legal advisor of the Danish government will submit a demand notice in which SCAT raises a claim against ARIA for repayment and compensation. That never happened. At some point, for reasons unknown to certainly me, if not my wider team, SCAT chose not to pursue the notification of an assessment to tax. They chose instead to flip things into a civil claim in this jurisdiction. The civil claim in this jurisdiction, my lords, seeks to recover the same sums. This is a 1.6 odd billion claim. Each of those claims is predicated necessarily on a wrong refund of income tax. Now, I don't need to deal, if I may say so, with situations outside of a tax environment, where, for the sake of argument, say there's a procurement exercise conducted by the Danish SCAT, whereby they procure software services from a variety of people around the EU, but as a result of conspiracy, they end up paying more for those services than they would have done otherwise. So there's cartelised bid rigging approach under competition law principles. Now that would be a fraud. That would entitle the SCAT to go against those people for fraud. And it's true it is that the SCAT is being deprived of money. What the SCAT is claiming here, fundamentally, is a refund of very specific tax levied under Danish law, pursuant to a double taxation convention, where they're asserting a sovereign right to get it back. That is the claim. This claim is a non-Danish based way of getting the same tax back. And that is what the claim is designed to do. How do I know that is what the claim is designed to do? Well, because the Danish Parliament has helpfully told us. My lords, that's Supplemental Bundle 1, Tab 4, page 1. And if we could bring it up, please, at the bottom half of that page, there's a section that starts in tandem with, I'm going to get the pronunciation wrong, Soik's investigation. Civil law measures have been implemented with the aim of recovering as much as possible of the total amount of approximately Danish kroner 12.7 billion. This includes measures to recoup the money paid for unauthorised refunds of dividend withholding tax via the bank scheme, amounting to approximately DKK 900 million. Overall, the criminal and civil channels serve the same fundamental purpose: to bring legal liability, civil or criminal, to bear for the unauthorised payments of refunds of dividend withholding tax and to recover the largest sum possible for Danish public funds. The tax agency now have a variety of legal remedies available, it's true. They can seek to enforce criminal liability, which they've done, and we've seen that they are now also seeking to trace and recover as much as possible. Now, the next part of my submission necessarily involves a submission that they could have done that through continuing with the tax assessment procedure and using MARD to secure the recovery of those sums in this country. And I'm going to, if I may, segue into MARD, with time evaporating before me, and make good the submission.
Could you just repeat that? You're going to segue into MARD with time disappearing in front of you.
Yes, it's a convoluted way of saying I'm watching the clock.
I think that's utterly brilliant at 4:15 in the afternoon.
She said with time evaporating.
Evaporating. Even better.
Extremely elegant for this time of day.
My lord, I'm very grateful. I'm planning to put that on my website, if I may. MARD is dealt with, obviously, as part of a separate submission, but I was also conscious that my Lord Lord Justice Stuart-Smith had earlier suggested, well, what are they meant to do? It was re-encapsulating, if I may call it the jury point, that's offensive to juries. It was encapsulating a point that depends on pure merit rather than legal analysis, is the way I'd prefer to put it. What we say in response is, well, MARD allows for precautionary measures to be obtained to support the recovery of tax debts. Please could we look at Principal Authorities, Volume 10, Tab 88, page 9. And one sees, I hope, under Article 16, a request for precautionary measures. Now, I don't have time to take my lords through the overall structure of this. Suffice to say that under MARD, what you need is an initial determination that there is a tax claim, which is a matter purely for the applicant state. And so, in this case, Denmark, if it says we've got a tax claim, notifies the UK takes that initial request for enforcement and works out whether it's final. If it's final, they then proceed to recovery procedure, in this, the requested state, to support. And what we see here is that ordinarily the UK couldn't proceed to deal with enforcement if there was still a contested debt. But when it comes to precautionary measures, what one sees is at the request of the applicant authority, Denmark, the requested authority shall take precautionary measures if allowed by its national law and in accordance with its administrative practices to ensure recovery where a claim or the instrument permitting enforcement is contested at the time when the request is made. So regardless of the fact that ordinarily you're going to have to deal with a contested dispute in the host member state, Denmark, here you can get the UK to help out by getting a worldwide freezer. Why do I say that? Well, we've got an example. As in Blue Peter, somebody has done it earlier. And one sees, my lord, Supplemental Respondent Authorities 3, tab 27, dramatic pause. One sees a decision, I hope, of His Honour Judge Pelling. In essence, the facts were established debt in South Africa, and one can scroll down, I hope, to the middle of the page. Established debt in South Africa, tax debt, a series of complicated company restructuring involving BVI companies and Guernsey companies to try and avoid the consequences of that. Attempt by South Africa then to enlist the help of the UK. The help of the UK came in the form, paragraph 4 of the judgment, which I hope is at page 4. Sorry, one moment. 6, thank you very much. Yes, top of the page, proceedings commenced, 2 separate actions. They chose to bring South Africa as a claimant as well as at HMRC. There was a reliance on the Double Taxation Convention. HMRC, one sees at paragraph 5, sought and obtained a freezing order against all of the defendants, and that was pursuant to a request for assistance under the relevant double taxation agreement between the United Kingdom and the Republic of South Africa. And that was an enforcement mechanism that enabled, in this case, HMRC to be brought to deal with, lawfully, a claim. Could we then please turn to paragraph 51? I'm afraid I haven't given myself the reference. Sorry. 26, thank you very much. Now, the claim by South Africa itself, brought in this jurisdiction as a co-claimant with HMRC, wasn't permitted. And it wasn't permitted because they were seeking to enforce a tax debt in this jurisdiction. Now, there was a separate issue as to the retrospective application of the Double Taxation Convention, which got short shrift. But in essence, the South African claim in its own right, with South African revenue authorities as the claimant, was rejected on the basis of the revenue law. And one sees at paragraph 53 that the answer to it was that it was precisely the width and scope of the revenue rule that had persuaded states to ensure that they could offer each other mutual assistance to recover cross-border tax debts. And for your Lordship's note, PA4, tab 28, page 1 is the Court of Appeals upholding that decision, albeit for the issue crystallised on appeal in a way that isn't relevant. Lord Justice Lloyd Jones, paragraph 6 of that judgment, nonetheless reiterated that the general principle of mutual assistance was to everyone's mutual benefit. Now, can I make something of a jury point, which is, it's fair to say I've been doing tax cases for a while for both sides of the fence, and I've dealt with mutual assistance a lot. I've given an example of a recent example of mutual assistance working in bringing the foreign taxpayer into this jurisdiction so that the tax debt can be enforced, and that's the whole point of MARD. You focus the liability where it should be determined, which is in the taxing state, which is consistent with the fiscal sovereignty of different states. You force people into this jurisdiction. What, with the greatest respect, would not have justified my Dicey and Morris subscription is my tax practice, because the revenue rule has very rarely been invoked in tax cases, and we know that this case is something of a novelty. But the reason it's a novelty is because usually tax authorities don't seek to enforce in another state an underlying tax liability. They rely on mutual assistance provisions provisions to do the heavy lifting. And if fraud were an answer, then this jurisdiction would be amenable to claims from the French government arising from smuggling operations of French wine into this jurisdiction, even though the excise duty was payable in France. And it would be a claim for fraud articulated on the basis that we have been deprived of French excise duty on the beer or cigarettes that have been smuggled. Take a more prosaic example, dependent upon not a fraud case. Say a wealthy individual who acts as a wine trader goes over to France and rather than using the in-bond system, buys a quantity of very expensive red wine, pays the French duty, brings it back to London and seeks to sell it. That would be holding those goods for a commercial purpose in the United Kingdom. UK excise duty would be payable, and HMRC would seek to insist that it was recovered and UK excise duty was paid. What then happens is the excise directive that I've cited in our skeleton permits the UK trader to say, right, I'm having to pay UK authority, it's on the same goods. Can I have a refund from the French authorities? If the French authorities refund that money, then there is a cross-border payment of tax back to that trader. Now imagine that there's then a conspiracy of these traders to pretend that they're selling goods in the United Kingdom and pretending that they're entitled to the refunds back. It still involves the French authority refunding the excise duty wrongly, and it would still amount, if they brought a claim for conspiracy before the commercial court, it would still amount to the indirect enforcement of the underlying excise duty. And that, in a nutshell, is this case. Fraud, with the greatest respect, can't make all the difference, doesn't make all the difference. Buchanan could not have been decided in the way it was if fraud made all the difference. And indeed, we've pointed to, sought to point to, a variety of practical reasons why, if fraud did unravel everything, then you would end up very quickly with a revenue rule that simply did not exist. Why? Because one doesn't need to engage the erudition of Malone and Friends' team to be able to plead a claim that makes no reference to the underlying tax dispute. You simply say, well, I've got a debt. The debt that's due, for the sake of argument in the United Kingdom, where there is unpaid VAT, that's recoverable as a debt to the Crown. Schedule 11 of the VAT Act, paragraph 5. Where there is an unpaid customs duty or excise duty, that's recoverable as a debt to the Crown. Section 137 of the Customs and Excise Management Act, 1979. You could simply plead a debt to the Crown, say it's a claim in debt, not touch the underlying tax basis, and enforce it in another foreign state.
But those are plainly recognised as being claims for tax.
Well, my lord, this case should be plainly recognised as a case for tax for the simple reason that it was open, and indeed we say should have been pursued as a tax assessment matter by the SCAT. All of the 1.6 billion reflects repayments of income tax.
My understanding is what you're saying to us is that this would drive a coach of horses through the dicey rule 3.
Well, there is no...
Because you're saying to us that in terrorum, that if we were to say this wasn't tax, that thereafter all revenues all around the world could come to us and say, look, we've got a claim in debt. Well, I'm sorry, that just doesn't wash as far as I'm concerned. Because each of those, we can look at the substance and say, well, you might say it's a debt, but it's actually tax which you're assessing. We're in a very different situation here. Now, you may or may not be right in your argument. I don't think you can go so far as to say that this would be the end of the revenue.
Oh,
can you?
My lord, I certainly intended nothing interor, if I may make that clear. I'm dealing with the...
Somewhat hyperbolic there, Mr. Peel, even for Opus 4.
Well, let me retreat to the comfort of Lord Collins, if I may, metaphorically, and say this. It's not so far-fetched to think that an MTIC fraud might be pursued by a revenue in another state, because we've seen examples of it.
Yeah.
Turn those facts around, plonk them into this jurisdiction, what should the court's answer be? My lord, I think I've probably strained both your patience and those behind me enough, unless anyone tugs my gown metaphorically. Those are the submissions on tax issues.
Well, thank you very much indeed, Mr. Peel. Thank you. Right, well, we'll adjourn until 10:30 tomorrow morning.
God rise.